Assalamualaikum warahmatullahi wabarakatuh. This is part 3 for Zoom recorded lecture for the topic misrepresentation. So in the first two parts, we have discussed about the conditions for an actionable misrepresentation. So now we are going to look at the types of misrepresentation. The classification is basically based on common law. Okay, so now once we fulfill all the elements, requirements, key conditions, so once misrepresentation has been established, so what's the next step? It is necessary to consider what type of misrepresentation has been made. We want to know what's the category, what's the type here, and then how does it be done here? I mean, on what basis the type is done. So misrepresentation is classified, is categorized based on the state of the mind of the representative, whatever in his mind at the time he made the representation. So basically, there are three types of misrepresentation under English law. And then, is it applicable in Malaysia? Yes, it is. Okay, so by way, I mean, it is stated clearly in the case of Simtong Realty and Take Him Down. So altogether, there are three types of misrepresentation. It's either fraudulent, negligent, wholly innocent. And then what's the importance of these categories or classification here? Okay, it is important to know what category is it, what category does it fall under, because different category has different remedy. So the distinction lies in the remedies available for each type. For example, now let's get to know what is, before we go to the remedy, let's get to know what is fraudulent misrepresentation. This is actually the term under common law. Okay, they have the term fraudulent misrepresentation, and it was defined by Lord Herschel in the case of Dairy and Pig, 1889, to mean a false statement that is made knowingly. Okay, it is false, and then when the maker of the statement made it, it was made knowingly. He knows about the false statement. Okay, and then it is made without belief in its truth. He doesn't believe it is true. Okay, or it is made recklessly. Okay, careless as to whether it be true or false. Doesn't matter. He doesn't bother about it. He just made it. Okay, so recklessly, he's not sure whether it's true or not. Okay, what if the maker of the statement makes the statement and then he honestly believes it to be true? Can we say this is fraudulent misrepresentation? No, okay, it cannot be fraudulent. Okay, so mean that here, what if he honestly believes it to be true, then it is not fraudulent misrepresentation. Okay, let's have a look at the facts of the case of Dairy and Pig here, 1889. Very old case. A special act incorporating a tramway company, provided that the carriage might be moved by animal power and with the consent of the Board of Trade by steam power. So based on this statement here, the directors issued a prospectus, and this prospectus contained a statement which referred to the act here. By this special act, the company had the right to use steam instead of horse. We are going to use steam, because based on the special act here. So after reading the prospectus here, plaintiff bought shares, because he believed the statement contained in the prospectus. But later, the Board of Trade refused to give consent to the use of steam. So that's why the company has to be wound up. The company goes bankrupt, basically. Okay? Now, plaintiff was not happy. So plaintiff brought an action for deceit, related to fraud just now. Okay? Fraudulent misrepresentation here. So the court held that, well, the defendants were not fraudulent in this case. Okay? They made a careless statement, but they honestly, that's the emphasis here. Okay? They honestly believe in its truth. They honestly believe it to be true. They believe in the truth of the statement because it was the cross referred to the special act, and Board of Trade has the right to give consent, but the consent wasn't given. Here there's no way. It's not fair to say that, oh, when you make the statement, you don't believe it to be true. I mean, they don't have any intention, okay, to cheat, okay. And then when we talk about fraud, okay, or fraudulent misrepresentation, the burden of proof is very high, okay. And then he who asserts fraud must prove it, okay. And then it could be difficult to prove fraud because we don't know what's in the maker's mind actually, okay. And for fraud, now we talk about remedy, okay. Remedy is rescission and okay, and damages both. But not damages for breach of contract, but damages for fraudulent misrepresentation. So can set aside the contract and can also claim for damages, but must prove it under the tort of deceit because both contract law and torts law is under civil claim. It's between individuals. So can get rescission as well as damages, monetary compensation. Okay, now let's compare fraud and misrepresentation, okay, or fraudulent misrep just now, okay, fraud and misrepresentation. So for fraud, whenever there is any element of fraud, the person making the representation does not himself believe in the truth, and burden of proof usually is very, very high. But for misrepresentation, burden of proof is slightly lower, okay, normal burden of proof, and the person may believe the representation to be true. I mean, most of the time, the maker of the statement believe it to be true. That's why it is a case of misrep and it's not a case of fraud or fraudulent misrepresentation. Okay, what is negligent misrepresentation? So it is defined as false statement made by a person, okay, the maker of the statement, who had no reasonable grounds for believing it to be true. And under English law, we can claim it under common law, under common law negligent misstatement, torts law actually, okay, the case of Halliburton and Heller, or they can claim it under statute as well because it has been codified under Misrepresentation Act 1967, but we don't have equivalent act here in Malaysia. So that's about negligent misrepresentation. That's why there's also statement made by certain legal jurists saying that this particular category maybe is not relevant to Malaysia because I mean, it could be provided the claim is made under torts law, so it's not so much under contract act or under English law, under contract law or under contract rule, okay, or under rule of contract law or under Contracts Act 1950. And after all, we don't have Misrepresentation Act 1967. Okay, we go to the third one, which is important, wholly innocent misrepresentation. So here it means a false statement in which the person makes honestly believe it to be true. So this is the normal misrepresentation, but then we stress on the innocent part. Okay, that's why it is known as wholly innocent misrepresentation, totally innocent misrepresentation. And then for this category, the remedy is rescission, but not with damages. Okay, because for fraudulent, rescission with damages. Here, rescission with an indemnity. We are going to look what is indemnity. So the case is here is Simpang Realty and Take Him Down. Okay, we have also the case of Bounty Dynamics. This is appeal case. It's good to discuss it here because the court actually give some interpretation, okay, application, explain it further. Okay, in what way the rule pertaining to misrepresentation is relevant or is expanded actually here. Bounty Dynamics Sdn Bhd, formerly known as Media Development Sdn Bhd, and Chow Tat Ming, and 175 others. So it involved many parties here. Okay, reported in year 2016. Okay, the respondent, because this is appeal case, okay, respondent, they were the purchasers, many purchases here. They signed sale and purchase agreement, SPAs, with the appellant. Okay, the appellant, the vendor. So the agreements were signed between years 1994 up to 1995 because it involved 176, okay, 176 lah, okay, the parties to the suit here. They wanted to buy, I mean, they really bought a commercial unit, okay, in a business complex, Summit Center, USC lah, okay, built by the appellant. And 10 years later, roughly, in 2004, okay, respondent now, okay, all the buyer, they wrote to the appellant to remedy its failure, okay, to construct the theme park because they thought there will be theme park, and also to reactivate the food court, okay, which has ceased to operate. And actually, on the part of the appellant, okay, the developer, okay, the one who construct the building, the appellant carried out various festive and promotional activities at the complex. Okay, and they are the one. They did secure tenants to run the theme park. Okay, but then tenancy was terminated in year 2001. Okay, 3 years before the action was filed. And the food court, they also, I mean, they have the food court, and they secured an anchor tenant for the complex. And this is argument by the respondent. They said, well, actually, when we decided to buy, okay, in an advertisement brochure, okay, published by the appellant, and it was distributed prior to before they signed the agreement, SPA, okay, the appellant in the brochure represented that the complex would have festive and promotional activities throughout the year. An anchor tenant of reputable standing, a 3-level amusement theme park, and a food court. I mean that here, they rely, okay, on the brochure. I mean, that's why they are now suing for misrepresentation. Okay, and this part of the thing is not really included in their SPA. Okay? If it is a breach of terms in the SPA, then no need to file a suit under misrepresentation. Okay, can just go straight to breach of contract. Okay, and then another argument by the respondent. Layout plans, okay, of the amusement theme park, okay, restaurant and entertainment outlets were not only contained in the brochure, okay, but were annexed in a schedule to the relevant SPA. I mean, there must be theme park, okay, restaurant and entertainment outlet. So meaning that here, despite the on top of brochure, it's also contained in the SPA. And they were all, okay, the purchaser here, were induced by the representation and layout plans in the brochure to enter into the SPA. So now they claim for both, actually, okay, they claim for both misrepresentation and breach of contract. Now they claim for damages, okay, for losses they had suffered because the business was so bad. It didn't turn up as what they had planned. That's why they brought the case to the court. So at the High Court, and they won the case. Okay, judgment was granted to the respondent. Okay, because a representation made by the appellant became a term of the SPA, and in not fulfilling them, the appellant was in breach of contract. So that's what the court said. And then the court said respondent had proven the damages they had suffered. Okay, for misrepresentation and for breach of contract. So they are entitled to monetary compensation. But the appellant was not happy. Okay, the one who constructed the building, the mall owner. Okay, appellant appealed to Court of Appeal, and this is decision by Court of Appeal. The appeal was allowed. In the year, the developer, the building owner won the case. Okay, the appeal was allowed, and High Court decision was set aside. And this is the reason. Okay, why the trial court decision was set aside here. The Court of Appeal said, looking at the character of the representations made by the appellant, okay, it showed that the appellant was to provide space, okay, not really the other one who operated the theme park or the food court. Okay, responsibility on their part is just to provide the space, and it was done properly actually. Okay, and then the court said, okay, the court checked, and then yes, there was actually the previous tenant, but because of the economic problem, okay, because of the prevailing economic conditions, the tenancy was terminated early. So before that, there was actually anchor tenant, there was the operator of theme park, okay, but then everything didn't go as planned, okay. And the court said, well, the appellant had also secured an anchor tenant in Fajar Retail Enterprise. So they had done whatever they promised actually. Okay, they promised to provide space, and they promised to secure tenants, okay, tenants to operate theme park, tenants to operate anchor tenant. Okay, so all was being fulfilled, the promise here. So there was no misrepresentation. So you can read all the reasons here. This is taken from the judgment actually. Okay. You can see in the last bullet there. Okay, once a representation became a clause in the contract, okay, such was as was argued here by the respondent, there could not then be an order for damages to be assessed for both misrep and breach of contract. It has to be either ground. Okay, if you're asking for compensation, is it based on misrep or is it based on breach of contract? We cannot allow them if you win. If the judgment is in favor, okay, of the respondent, and then the damages that might be allowed is either one. Is it under misrep, or is it under breach of contract? Okay, and then in the brown box there, okay, no evidence of deceit or fraudulent misrep. Okay, so this is a case of innocent misrepresentation. So why the case is important? This is example of innocent misrepresentation. So no damages for innocent misrepresentation. Only I mean, if the case is proven, only can set aside the contract and also can claim for indemnity. Okay, so basically there's no, but after all the court said, well, no misrepresentation. Okay, in this case. Okay, this is the last part of our topic. Okay, effects and remedies. So what happened to the contract which is affected by misrepresentation? So if the party can prove there was an actionable misrepresentation, so the contract will become voidable under section 19, subsection 1, Contracts Act. I mean, the same section that we discussed for the topic coercion. Okay, and then once an actionable misrepresentation has been established, so then the next step is to consider the remedies, because different remedies for different types. That's why we have to know what types of the misrepresentation. So basically there are three remedies, rescission, indemnity, and damages, depending on the types of the misrepresentation. So what is rescission? To set aside the contract. And rescission is possible in all cases of misrepresentation. I mean, the party has the right to rescind, provided it is an actionable misrepresentation. So what's the aim of giving rescission here? To rescind the contract, to put the parties back in their original position, okay, on the basis that as if the contract had not been made. So we restore back the party to their earlier position. And then we discuss it under undue influence, actually, okay, by way of giving notice or apply to the court. So it's the same thing here. And this is the limitation to rescission. I mean, in some situation, we cannot apply, we cannot give, we cannot award rescission. It cannot be, I mean, it cannot be done, basically, rescission here. For example, if the party affirm the contract, or sometimes restitution in integrum is not possible. We cannot really restore you back to their earlier position. Or even if third party has acquired rights, okay, and the third party is bona fide purchaser for value without notice. It's the same discussion like we have for the topic undue influence, actually. Yeah. Okay, we have another case which is relevant. The case explain, I mean, somehow it explains further, okay, how to apply the remedy here. The case is this is decision by federal court, so that's why it's important. At Maralkov Developments Yang Berhad and Balakrishnan, Analaki Devarash, and another. In this case, okay, the rule that we derive is that rescission, okay, it relates to rescission. Rescission of an executed contract, okay, could not be done, okay, for mere innocent misrepresentation, okay, unless it rendered the subject of the sale different from what was contracted for. I mean, rescission is not also possible. Okay, it's not allowed in this particular situation. Okay. And then after all, the finding was that, okay, property did not differ so completely, okay, in substance from what the respondent intended to acquire. And the conduct of the respondents after accepting the keys to the property showed an election to affirm the agreement. So after all, they affirmed the agreement. I mean, they complained about it later, and they tried to prove their case under misrepresentation. They were not happy with the apartment, with the condo that they have bought. But they waited until 4 years, I think. Then only they brought the case, and then they argued misrepresentation. So you stated here, long lapse of time without complaint showed intention to affirm the contract. And it was a strong indication, okay, that they were not really induced by whatever was said by the appellant servant or agent to enter into the agreement. And there was a delay of more than 4 years, actually, okay, before the respondent decided to pursue the action for rescission. So the delay affect their rights, actually, to set aside the contract. And this is all the related to the earlier slide just now. Okay, there was misrepresentation, okay, but remedy was not available here. Okay, the court held that the representative who had been induced by an innocent misrepresentation may sue for rescission and consequent restitution, okay, provided the contract was still executory and if all the parties could be restored to their original position. So we cannot allow for rescission. I mean, we cannot order for rescission because it's not possible. Everything is done. Okay? Everything is final and complete here. And as far as the case was concerned, there was a delay as well. Okay, you can read all the facts in the bullets. This is just the, taken from the actual judgment, federal court judgment. Okay, this is another remedy, indemnity. What is indemnity? Okay, so order of rescission may be accompanied by the court ordering an indemnity. So indemnity, it means money payment, okay, by the misrepresenter in respect of expenses necessarily created, okay, in complying with the terms of the contract. And it's not damages, okay, it's not monetary compensation here. Example of indemnity here, any contract for the sale and purchase of the house, okay, purchaser not only pay the purchase price, but purchaser must pay legal fees, stamping fees, whatever expenses in relation to the completion of sale and purchase agreement. So can claim this, all these expenses by way of indemnity. Okay, we don't call it damages here, we call it indemnity. So it is applicable. It is relevant to wholly innocent misrepresentation. And damages, okay, the last one, damages. Damages is only allowed in cases of fraudulent misrepresentation, and usually it is claimed by way of torts, okay, torts of deceit. Because for contract law, usually damages for breach of contract. Okay, you can have a look at the meaning of tort of deceit here. Okay, the last case, I think. Okay, the last case, Abdul Razak bin Datuk Abu Sama and Shah Alam Properties dan Berhad, 1999. So we zoom to the rule that we extract from the case here. Okay, the court held that in the case of fraud, okay, the misled party is entitled under Section 19, okay, to a decree of rescission, can rescind the contract, and also the party can claim for damages. And damages here is to restore the victim to the position he occupied before the representation had been made. So that's the purpose of allowing or awarding damages or monetary compensation. It's different with damages for breach of contract, but still it is about damages, monetary compensation. So with that, we complete our discussion for the topic misrepresentation. That's all, okay, for the topic. Thank you.